Right now, in a federal courtroom in Chicago, lawyers for the United States government are preparing arguments that could determine whether Illinois' sweeping ban on certain rifles and magazines stays on the books or gets struck down for good. The Department of Justice under the Trump administration has made a calculated, unprecedented move that signals a dramatic shift in how the federal government views state-level gun restrictions. And if you've been watching this story unfold, you know that what just happened is about to reshape the entire debate over the Second Amendment in America. In this video, we're going to break down exactly what the DOJ just did, why it matters, what it means for the state of Illinois, and what you should be watching for in the coming weeks and months. By the end, you'll understand the legal landscape better than most people covering this story. You'll know which arguments carry weight, which courts are watching, and what the real timeline looks like for resolution. Most importantly, you'll understand why this isn't just about Illinois. It's about how the constitutional right to bear arms will be interpreted for every American going forward. Let's start with the basics because this story has layers, and we need to understand them to see the full picture. Illinois passed its law, the Protect Illinois Communities Act, commonly known as PICA, in January of 2023, just months after the Supreme Court issued its landmark ruling in New York State Rifle and Pistol Association versus Bruin. That Supreme Court decision established a new standard for evaluating Second Amendment challenges. Courts must look to the text of the Constitution and the historical traditions surrounding the regulation of arms, rather than balancing public safety interests against the right to bear arms. Think of it this way. The old approach asked, does this law make sense for public safety? The new approach asks, does this kind of regulation have historical precedent in American law? It's a fundamentally different test, and it made a lot of existing gun laws suddenly vulnerable to legal challenge. Illinois lawmakers knew they were walking a tightrope when they passed PICA. The law banned what it called assault weapons, a category that includes common semi-automatic rifles like the AR-15, and magazines capable of holding more than a certain number of rounds. It also required people who already owned these firearms to register them with police or face potential criminal liability. Supporters called it a reasonable public safety measure. Opponents called it a direct assault on constitutional rights. Both sides knew this would end up in court, and both sides were right. The legal challenge came quickly. A coalition of gun rights organizations, including the Firearms Policy Coalition, the Illinois State Rifle Association, and the Second Amendment Foundation, filed suit in federal district court, arguing that PICA violated the Second Amendment as interpreted by Bruin. The district court initially sided with the plaintiffs, issuing a preliminary injunction that blocked enforcement of the ban while the case proceeded. But then the case went to the U.S. Court of Appeals for the Seventh Circuit, which covers Illinois, Indiana, and Wisconsin, and that court reversed the district court, allowing Illinois to continue enforcing PICA while the litigation continued. The Supreme Court then declined to intervene at that early stage, which brought us back to the district court for a more final determination. Now here's where things get interesting. The district court went through the full analysis under Bruin, and it concluded that PICA's bans on commonly possessed semi-automatic rifles and standard capacity magazines were unconstitutional. The court entered a permanent injunction, meaning Illinois could no longer enforce those provisions. That should have been the end of the story, at least at the trial court level, but Illinois immediately appealed again to the Seventh Circuit, and that court issued a stay, putting the injunction on hold while it considered the case a second time. So we had a situation where the district court said the law was unconstitutional, but it remained in effect because a higher court put the ruling on hold. That created a bizarre legal landscape where Illinois was technically enforcing a law that a federal court had found to violate the Constitution. People were facing potential criminal charges for possessing firearms that a court had said they had a constitutional right to keep. This tension is exactly what brought us to where we are now. If you're finding this breakdown useful, subscribe now and turn on notifications. We're tracking these developments in real time, and the next ruling could change the entire picture in a matter of days. This story is moving fast, and you don't want to miss our coverage when it does. Now let's go deeper into what's really driving this moment, because the DOJ's involvement is the crucial new factor that changes everything. In June of this year, the Civil Rights Division of the Department of Justice filed a 34-page amicus brief with the Seventh Circuit. For those who aren't familiar with legal proceedings, an amicus brief is essentially a document where an interested party, not one of the direct litigants, offers its perspective on the legal questions at stake. Organizations like the NRA or the Brady Campaign often file such briefs. What makes this one unusual is that the United States government itself, meaning the executive branch through the Justice Department, took the extraordinary step of filing a brief arguing that Illinois' PICA law is, quote, flatly unconstitutional. That's not neutral language. That's not a careful balancing of competing interests. The DOJ is telling the Seventh Circuit that the law violates the Second Amendment and should be struck down. The brief makes several specific arguments. First, it says that PICA bans arms that are commonly possessed by law-abiding citizens for lawful purposes, and that such bans cannot survive constitutional scrutiny under Bruin. Second, it argues that the Seventh Circuit previously misapplied the Supreme Court's test when it reversed the district court's preliminary injunction. And third, it urges the appellate court to affirm the permanent injunction issued by the district court. The brief also reveals something important about the Trump administration's approach to the Second Amendment. It cites an April 2025 memo from Attorney General Pam Bondi that states, quote, "For too long, the Second Amendment, which establishes the fundamental individual right of Americans to keep and bear arms, has been treated as a second-class right. No more. It is the policy of this Department of Justice to use its full might to protect the Second Amendment rights of law-abiding citizens." That language is striking. The DOJ is explicitly adopting a position that the right to bear arms deserves the same level of protection as other constitutional rights, and that the federal government will actively defend that position in court. But the DOJ didn't stop at filing a brief. It also filed a motion requesting permission to participate in oral arguments before the Seventh Circuit. The court granted that motion, meaning a representative from the Solicitor General's office will actually appear before the judges and speak directly to them about the constitutional issues at stake. The DOJ will have 5 minutes of argument time, seated by the plaintiffs, to make its case. That's not a lot of time, but it sends an enormous signal. When the United States government asks to appear before an appellate court and argue that a state law violates the Constitution, judges pay attention. They know this isn't just another interest group trying to influence litigation. This is the executive branch of the federal government taking a formal position on a question of constitutional law. What would you do if you were in the position of the Seventh Circuit judges right now? You have a state law that a district court has found unconstitutional under recent Supreme Court precedent, and now the Department of Justice is telling you that the lower court got it right and that you should affirm that ruling. The political implications are enormous. The legal implications are clear, and the court has scheduled oral arguments for September 22nd. Let me break down what comes next and what scenarios we're watching for. Scenario 1, and this is the one most legal observers consider most likely, is that the Seventh Circuit, facing this new DOJ brief and the explicit position of the federal government, reverses course from its earlier ruling and affirms the district court's permanent injunction. If that happens, PICA would be blocked from enforcement, and Illinois would face the prospect of either rewriting the law to comply with constitutional requirements or watching it be struck down entirely. This would be a major victory for gun rights advocates and would signal that the post-Bruin legal landscape is even more favorable to challenges of assault weapons bans than many had assumed. Scenario 2 is that the Seventh Circuit maintains its earlier position and again rules in favor of Illinois. In that case, the plaintiffs would almost certainly ask the Supreme Court to take up the matter. Given the Supreme Court's recent track record on Second Amendment cases and the DOJ's explicit support for the constitutional challenge, the court might be more inclined to grant review. But there's a timing issue here. The Supreme Court takes cases slowly, and if the Seventh Circuit rules against the plaintiffs, the case could be in limbo for months or years before the justices decide whether to intervene. That means PICA could remain in effect while the litigation grinds forward. Scenario 3 is something unexpected, a settlement, a legislative fix, or some other development that changes the legal calculus before the Seventh Circuit issues its ruling. This is less likely but not impossible. Illinois could theoretically amend PICA to address constitutional concerns, though that would require significant political capital and would almost certainly be attacked by the law's supporters as capitulating to gun rights activists. Or the parties could reach some kind of negotiated resolution, though that seems unlikely given the fundamental disagreement about constitutional rights at the heart of this dispute. What are the specific triggers to watch? First, the September 22nd oral arguments. Pay attention to what the DOJ's representative says and how the judges respond. Courts often signal their thinking through the questions they ask. Second, watch for any Supreme Court petitions if the Seventh Circuit rules against the plaintiffs. The timeline for those petitions is tight, and a Supreme Court decision to hear the case would be a major development. Third, pay attention to similar cases in other jurisdictions. New Jersey has its own assault weapons ban, and it's being challenged in the Third Circuit. Colorado and the District of Columbia are facing similar DOJ lawsuits. If courts around the country start striking down these laws in a consistent pattern, that creates enormous pressure on the remaining states to either change their laws or face constant litigation. Here's what this means for ordinary people in Illinois. Right now, if you own a firearm that falls under PICA's restrictions, you're in a complicated legal position. The law remains technically in effect because of the Seventh Circuit's stay, but a federal court has said it's unconstitutional, and the DOJ agrees with that assessment. You could face criminal charges if you're caught with the wrong weapon, but the legal ground beneath those charges is shifting rapidly. This uncertainty is exactly what gun rights advocates have been arguing about. It creates a situation where law-abiding citizens don't know what conduct is actually legal, and they face the prospect of being criminalized based on laws that may not survive constitutional review. For supporters of PICA, the stakes are different but equally high. They believe these restrictions save lives by limiting access to weapons that they argue are designed primarily for mass casualty events. They point to mass shootings as justification for aggressive gun control measures, and they see PICA as a reasonable exercise of the state's police power to protect public safety. If the law is struck down, they'll argue that courts are prioritizing gun rights over the safety of ordinary citizens, and they'll push for legislative responses that might include constitutional amendments or other measures to preserve the restrictions. This brings us to a larger point that often gets lost in these debates. The Second Amendment is not just about guns. It's about the relationship between individual citizens and the state. It's about the question of what rights are so fundamental that they cannot be removed by legislative majorities, no matter how compelling the public safety arguments might seem. The DOJ's brief essentially makes this argument explicitly. When a law bans arms that are commonly possessed by millions of law-abiding Americans for lawful purposes like self-defense, sport shooting, and collecting, it cannot be reconciled with a constitution that protects the right to keep and bear arms. Share your perspective in the comments below. Does the DOJ's position in this case change how you see the future of gun rights in America? Your insights help us all see angles we might miss. While you're thinking about that, consider this next piece of the puzzle, why this moment is different from anything we've seen before in the long history of Second Amendment litigation. For decades, the federal government's position on state gun laws was essentially agnostic. Presidents of both parties generally allowed the Justice Department to take a neutral stance, or in some cases, actually supported restrictions on firearms. The Obama administration advocated for bans on assault weapons and high-capacity magazines. The Trump administration initially took a more favorable stance on gun rights, but it was primarily through regulatory changes and political rhetoric, not necessarily through aggressive litigation positions. The Biden administration was openly hostile to expansive Second Amendment claims and often supported state-level gun control measures. What we're seeing now is different. The DOJ isn't just declining to defend Illinois' law, it's actively arguing against it. And it's not just arguing against it on policy grounds or as a neutral arbiter interpreting the Constitution. It's taking the position that PICA is unconstitutional because the Second Amendment protects an individual right to keep and bear arms that applies against state governments, and that right includes access to the types of firearms covered by PICA. This is a complete reversal of how the federal government has approached these questions for most of American history. The implications extend far beyond Illinois. In August, the DOJ filed similar lawsuits challenging Colorado's assault weapons ban and the District of Columbia's restrictions on semi-automatic rifles. These cases are moving through federal courts right now, and the DOJ's position in the Illinois case will almost certainly be cited in those proceedings. If the Seventh Circuit upholds the district court's injunction based on the analysis supported by the DOJ, that creates strong precedent for striking down similar laws elsewhere. Courts in other circuits will have to grapple with the same constitutional questions, and they'll have the benefit of seeing how the DOJ argues the issues in the Illinois case. But there's a deeper story here about federalism and the balance of power between states and the federal government. Illinois passed PICA based on its own assessment of what the state needed to protect public safety. The law went through the normal legislative process, was signed by the governor, and was implemented through the state's law enforcement apparatus. From one perspective, this is exactly how American federalism is supposed to work. States serve as laboratories of democracy, experimenting with different policies to address common problems, and the federal system allows for diversity and local control. From another perspective, though, the federal constitution sets outer boundaries on what states can do. And when a state law violates constitutional rights, the federal government has a responsibility to step in and correct the error. The DOJ's brief essentially makes this argument. It says that PICA violates the Second Amendment, that the Supreme Court has established clear standards for evaluating such claims, and that federal courts have an obligation to strike down laws that don't meet those standards. This isn't just about guns, it's about the basic question of whether constitutional rights can be overridden by state legislation, no matter how popular that legislation might be. What does this mean for the broader landscape of gun rights litigation? The short answer is that we're in uncharted territory. The Supreme Court's Bruin decision was only a few years old, and courts are still working out what it means in practice. The DOJ's involvement adds a new dimension that could accelerate the development of this area of constitutional law. When the federal government takes a clear position on a constitutional question, lower courts pay attention. They know that their rulings might be reviewed by higher courts, and they know that the executive branch has resources and expertise that can influence how cases are decided. But we should also be realistic about the limits of what the DOJ can accomplish through litigation. Courts are independent, and judges are supposed to reach their decisions based on the law, not on political pressure or the preferences of the executive branch. The DOJ can file briefs, participate in oral arguments, and make its views known. But at the end of the day, the Seventh Circuit will decide this case based on its reading of the Constitution and the Supreme Court's precedents. The DOJ's position is influential, but it's not determinative. Here's what to monitor in the news this week and next. First, watch for any developments related to the September 22nd oral arguments, whether there are pre-argument motions, additional briefs, or statements from the parties about what they expect to happen. Second, pay attention to what happens in the parallel cases in Colorado and the District of Columbia, because if the DOJ wins in Illinois, those cases will likely move faster as courts feel pressure to reach consistent conclusions. Third, watch for any legislative activity in Illinois. Lawmakers might try to amend PICA to address constitutional concerns, and that would change the legal landscape significantly. What about the political dimension? Illinois is not a state that was going to quietly accept a court order striking down its gun control law. Governor J.B. Pritzker has been a vocal supporter of PICA, and he's made it clear that he believes the law is constitutional and necessary for public safety. There's already talk about legislative responses that could include things like constitutional amendments or other measures to preserve the restrictions. This could become a major political battle, with gun rights advocates on one side and gun control supporters on the other, each trying to use the political process to achieve what the courts won't give them. Does this change how you see the balance between federal and state power in America? Many people have strong opinions on this question, and the answer often depends on which side of the issue you're on. If you support strong gun control, you probably think states should have wide latitude to regulate firearms in ways that reflect local values and safety concerns. If you support expansive gun rights, you probably think constitutional protections should apply equally everywhere, and that states shouldn't be able to ban commonly owned firearms simply because they believe such bans will reduce violence. Both perspectives have merit, and both have deep roots in American political culture. Let me bring this together by looking at where we go from here. The Seventh Circuit's ruling in the Illinois case will be one of the most important Second Amendment decisions in recent history. It will either confirm that the post-Bruin landscape is as favorable to gun rights advocates as they believe, or it will show that courts are still willing to uphold significant gun control measures, despite the Supreme Court's new standards. Either way, the decision will shape the litigation strategy for similar cases around the country, and it will influence how state lawmakers think about guns for years to come. The DOJ's involvement adds weight to the gun rights side of the argument, but it's not a guaranteed win. Courts have to decide cases based on the law, and there are still significant questions about how Bruin applies to specific types of regulations. The Seventh Circuit might rule for the plaintiffs, or it might rule for Illinois, or it might do something more complicated like modify the scope of the injunction while still allowing most of PICA to remain in effect. We won't know until the decision comes down, and that could happen in the coming weeks or months. What we do know is that this is a pivotal moment in the long-running debate over gun rights in America. The legal landscape is shifting, the political stakes are high, and the outcome will affect millions of people who own or want to own firearms. Whether you think this is a victory for constitutional rights or a dangerous weakening of public safety measures, the fact is that the stakes are enormous, and the resolution is coming faster than many people realize. If you found this breakdown valuable, subscribe for our next deep dive. We're already tracking the next major development in this case, and it could change the entire picture before the month is out. The legal system moves slowly until suddenly it doesn't. And when the Seventh Circuit rules, everything we're discussing today will become concrete reality for people in Illinois and beyond. The bottom line is this: the Department of Justice has taken an unprecedented position in support of Second Amendment rights, and the courts are now deciding whether Illinois' sweeping gun ban can survive constitutional scrutiny. This is a story about rights, federalism, and the proper role of government in regulating firearms. It's a story that will be decided in the next few months, and it will set the stage for everything that comes after. Stay informed, stay engaged, and don't assume you know how this ends, because the answer isn't clear yet, and the outcome matters too much to guess.